Thank the gentleman very much. I think next up on our side, Mr. Harris from Maryland is recognized.
Thank you very much, and thank you, both of you, for being here today. Let me follow up with the questions from the gentleman from Tennessee about what is affectionately referred to as ambush elections. Because I tried to figure out why you'd call them ambush elections, so you're going to have to educate me a little bit on this rule. So the way my understanding kind of compresses the time frame for elections, so that which is triggered on, I guess, when a petition for representation is somehow transmitted to the employer. Is that from the NLRB, that petition for representation? How does the employer notify that this time frame is triggered?
Well, the petition is filed with the NLRB, and a copy of that petition is supplied to the employer.
The same day that it's filed with the NLRB?
Pretty close.
And my understanding now is that within 8 days there has to be that first hearing, is that right? 8 calendar days?
Yes, but there is leave for extensions with appropriate cause.
Right, but that's an NLRB decision. I mean, the rule says it's 8 days.
Yes.
Okay. And by the noon of the day before that 8th day, basically the employer has to have all I guess, submit something to the NLRB that sets out its statement of position. Is that what it's called? With regards to whether or not the representation unit is appropriate, things like that.
Well,
there is a deadline the day before.
There's a deadline
right.
to provide a statement of position right. The day before the hearing.
Noon of the day before.
The hearing
right.
is to take
at noon,
place.
Not close of business, noon, is that right?
That's right.
Okay. So, and I'm just thinking about this as a physician. I would imagine, and maybe I'll ask Mr. Griffin, I would think labor law is pretty specialized. You don't go to just a general practitioner who does wills and estates when you're doing a labor law negotiation. I'd imagine. Is that right?
Well, certainly the labor bar would make that contention.
Sure, sure. And you, I imagine, was a member of the labor bar.
I am a
So
member.
Do you make that contention?
I agree with that.
You
yes.
do? Do you think NLRB law is kind of a subspecialty? You know, having...
Well, having practiced labor
Yeah.
law, at one point in time, and I've done it for now about 34 years, at one time the board law was basically the central body of law that you had to
Right,
know.
so it's pretty subspecialized.
It is, but you have ERISA, you have a
You
number
wouldn't
of
go to a
others.
family practitioner to do a hip joint replacement, and you wouldn't go to a general
I have
practice
had
lawyer.
a hip replaced,
and
I
you
would
didn't go
not
to a general
family-
practitioner. And just
no,
like that, you
you're
wouldn't
correct
go.
about that.
You wouldn't go to a general practitioner to deal with a labor NLRB representation. I'd imagine. I'm just again, this is outside my field.
I'm not arguing with you, I'm agreeing with you.
Good. Okay. Now, I represent a pretty rural area with small employers. Is it true that the median number of employees who, in a petition for representation in 2014, because this was testimony before one of the other committees earlier this year, is 28 employees? That's the median number?
The elections conducted by the board over the last 10 years, the median number in elections that have been conducted has been between, I think, 23 or 24 and 28. It's
Right, so that's kind of small. So, and I'm in a rural area. A lot of my employers are in that ballpark, maybe even less. I imagine very few of them have in-house counsel. And I imagine none of them have in-house counsel that is actually specialized in NLRB law. So what they would have to do, and let's just pretend that the union, because it actually understands that this deadline sped up, files the petition Thursday before Labor Day. By your laws, that hearing has to be next Friday, right? 8 calendar days.
It's business days.
I think it's calendar. I don't know, the testimony in front of the, you sure it says calendar days for that hearing?
I don't recall. Calendar.
Oh,
I'm sorry, my bad. Calendar days.
Wow, let me get it straight. The General Counsel of the NLRB got that critical question wrong? You needed to turn around and get, Mr. Chairman, I'm amazed. But let's go on. So it's filed for next Friday. So my small employer has to find a subspecialist lawyer the day, and my understanding, this could be filed by close of business on Thursday. It doesn't have to be noon. It doesn't say filed by noon, does it? The petition. So at close of business Thursday, the employer finds out and has to find a specialized lawyer to prepare a pretty in-depth statement of position and have it ready by Thursday after Labor Day, and if they don't include something in that statement of position, it can't be entered at the hearing, they can't bring it up at the hearing? Is my understanding, look, I'm just a doctor, I'm not a lawyer. Mr. Griffin, is that my understanding, that if they don't have it included in that statement of position, they can't introduce it at the hearing next Friday after Labor Day?
My understanding is that if you don't have the issue raised in the petition, or you don't have it in the statement of position, that you cannot raise it in the hearing.
Mr. Chairman, I'm going to yield back, but I got to tell you, I now understand why it's called an ambush election. Thank you.